when I was kind of going around doing a little recruiting, come down to the class, we're going to be talking about end-of-life planning. I got a lot of funny looks, like, what are you telling me, end of life? But Scott Bloom is here to tell us why that's not a bad thing to say, no matter how old you are. So I'd like to introduce Scott Bloom. He's here from the Scott Bloom Law Offices to talk about end-of-life planning and why it's a good idea no matter how old you are, and what happens if you don't. So without further ado, I will introduce Scott. Thank you for being here with us.
Really appreciate it. Thank you everybody for coming out. I am an elder law and estate planning attorney. So I deal with long-term care issues. I deal with people getting sick, going into nursing home, Medicaid, that type of stuff. But realistically, I'm going to start with estate planning, basics of estate planning. I hear the term all the time. It's a lot of convoluted stuff. Estate planning can basically mean anything, but from my perspective, for what I deal with, estate planning has three basics. Power of attorney, so that you name somebody to be your representative for financial issues. A healthcare power of attorney, somebody that can make healthcare decisions for you if you can't make them. And then, end of life, you have assets, where do you want them to go? That could be a will, that could be a trust, that could be a combination of the two. But those three issues are what we deal with all the time. Either people have them in place or don't have them in place, and then we have to deal with that problem too. There is no uniformity to these documents. So it's not uncommon for me to have somebody come in with a power of attorney. Maybe it's a long-term care issue and they want to try and preserve some assets. I might not be able to do that with the power of attorney that they have in place. There has to be certain provisions in the document to allow somebody to maneuver assets, take them out of their name, those kind of things. We're long past the day where a power of attorney says, I name my son Joe to be my power of attorney, he can do anything I can do. We're past that. Nobody will accept that anymore. It has to be specific, to the point where I think my document's about 24 pages long now, before the signature pages, because we just name everything, every possible thing. The newest stuff I think we added was dealing with this Bitcoin and digital assets, those types of things. So the world changes. Those are the kind of things you have to get in place. A lot of people go, I don't want to do that, I'll do a power of attorney when I get sick. Great concept, if you're able to do it at that time. Problem is, if you wait too long, it's something that you have to do while you're cognizant. Yeah, true. You have to be able to do it, because if you don't have a power of attorney, if you don't have an agent, I have a case right now that I have to open, I have to go to court and get a guardianship. The dad never did a power of attorney, has two sons, he's now in a long-term care facility, they can't pay the bill. We can't apply for Medicaid, I can't do anything because hands are tied, I can't get access to assets. So we have to now go to court, have a judge name the son as the guardian, and go through that full process. So rather than spending, I don't know, a couple $1,000s to get all these documents and stuff in place, to get that planning in place, they're gonna be spending 10 grand to get that. And there could be issues. The problem that most people don't realize is just because it's the son doesn't mean the court's going to name him. Meaning if the son has a criminal record, has terrible credit, has 3 bankruptcies on his record, he's never going to be able to pass muster for the court, where they might then name an individual, somebody that's not a family member. That sometimes becomes a problem. So it's a point of going, these kind of planning techniques, do them while you have control, because they're for you. I have a power of attorney in place, I have a healthcare power of attorney in place, I have a will in place. My power of attorney is, in my case, my brother. He doesn't have the document. He's not acting under it. He knows where to find it if something happens to me. So sometimes people are overly concerned about that, going on, I don't really want somebody in charge of me. Power of attorney is not in charge of me. It's not how they work. It's a document that states this person can do all of these things, basically everything you can do. You're basically duplicating yourself. Still a serious document, because they could abuse it. They could go to the bank. They could take all your money out of the bank account. You see those episodes of Law and Order. That's where these things come from. So that's where you get that kind of idea from. It's happens. So the point is, you choose the right person. It all falls on you to pick the right person. So healthcare power of attorney, again, that's a simple one. I can't answer the questions for the doctor. What am I supposed to do? I know people hear the word living will. You won't hear me say that all that often because I don't really like a living will. And the reason being, I'll use a specific situation I'm going through. A friend of mine is going through. I don't want to steal her thunder with this, but a living will basically, the document says, I don't want any artificial respiration. I don't want any extraordinary measures. I don't want. Okay. None of us want to live on a ventilator. I apologize for guessing, but I'm going to just make a guess. The issue that this woman had with her father was he was taking some medication. He ended up having some swelling in the brain. The brain was telling the lungs not to breathe. So they wanted to put him on a ventilator, see if they can get the swelling down, calm the situation. If you only had a living will, the document says no ventilator. Doctor's hands are tied. That's why I personally like to do a healthcare proxy, healthcare power of attorney. Somebody to be able to answer that question. To take all those factors, know that my dad doesn't want to live on a ventilator, but most certainly would want the opportunity to be on it for 5 days, for 6 days, come back off, let's see where it goes, go back on. That happened for a few months, back and forth. He's actually home. There's some damage from the swelling, but he's still alive. It was touch and go for a moment, but there was the ability to make those decisions. And that's what the difference is, rather than being stuck as attorneys, we call it, being bound by the four corners of the document. A piece of paper, I gotta do whatever it says. There's no subjectivity there. In this kind of situation, making a decision for medical, I think you want some subjectivity. Sometimes there's decisions that have to be made. So, and it's probably the least legal of the documents. It's more of a waiver for the doctors, not to avoid HIPAA, which is just a federal protection of privacy. But it gives you the ability to make a decision. It might be the toughest one to pick, because you got to pick somebody that can do it, that's going to answer for you, that's going to do what you want. So you then have to think about, all right, who do I name to do that? Well, my daughter. Yeah, well, will that be a hardship for her? Will she be able to make that decision? Will she live the rest of her life with the guilt? I don't know. Things to think about. Definitely things to think about. I had a grandfather who didn't want to name any of his 3 kids, named his son. That was his decision. Didn't want to put any of them in a position to make that choice. That was fine. He wanted me to do it, but I couldn't do it because I had to write the document. So ultimately, that's the way these work. I can't do something if I'm writing the document. But I was there at the end. He actually made his decisions all the way up to the end. Couldn't open his eyes, couldn't talk anymore, but he was there. We know because we asked him yes and no questions, 1 for yes, 2 for no, he can move his fingers. And he gave us answers. He was able to give the doctors answers. And that's hopefully how this works out, because we don't know where it's going to go. I do healthcare power of attorney and financial power of attorney for younger people too. You turn 18, all of a sudden you're an adult, go away to college. I got a son that's in his 2nd year of college. And I got a daughter, 17, turns 18 next year. I've already written hers. When they hit 18, I have them sign it. That way, God forbid something happens, I can speak. Because otherwise, they're an adult. So it leaves me that ability to do that. So we do a lot of those, especially in the springtime. Kids are graduating from high school. We hear from people a lot of times for those kind of things. But those are the documents. Those 2 documents are basically what's created to do the plan of basically naming somebody to represent you, to be able to do it. It doesn't hurt to have it. If you're concerned about, well, I don't want them to have it now, that's fine. Get the documents done, put them in the safe. Something happens to me, okay, here's where they are, go get them. And then they can act. You don't have to implement it today, but get it in place. That way you have it. Because again, if you become incapacitated, you're not getting it later. For me to be able to draft it, I have to have the conversation. Somebody calls, says, I have to get a power of attorney for my mom. Okay, so you want to do a power of attorney, want me to do a power of attorney for you, naming your mom as your power of attorney. No. Mom's going to name me. Okay, well, I need to talk to mom. Well, mom's in the hospital. She's unconscious. She's this, she's that. I get it. You just don't understand the concept. You can't do that. And if you think it all the way through its logical conclusion, you can see why. Yes?
You mentioned putting it in place now, but you don't necessarily have to implement it. But if you have this document hidden off in a safe somewhere, who needs to know that it's there, or so that they know
The agent, the
Okay.
agent, the person who's going to act under it, because they're the ones that are going to need it.
Sometimes your doctor's offices will ask for it too, is that
Could.
some place you could follow?
They could.
Okay.
A lot of times they don't really know all the terminology, so they ask if you have a healthcare representative or do you have a living will. So you most certainly can present it to them. You know, some ask, some don't. As you get older, they're definitely going to start asking. Those are fine. The healthcare representative, what I find in my practice is, for the most part, it's the financial one that people are afraid of. They're afraid of giving permission for somebody to know what I have. Even to the point where it's like, well, I don't want to call the lawyer and do a will because, you know, I don't want to talk about what I have. And that'll lead me into the next thing. Actually, unless I'm doing estate or asset planning and we're trying to protect assets, I don't care what you have. As long as you know what you have. For me to do a plan for you to get it from here to there, I don't need to know what you have. I don't want to know what you have, and I won't remember it 15 minutes later because it's not important to the plan. The plan for me is that you understand your assets. And that leads us to what happens is after you got that stuff while you're alive, when you pass away, you want your stuff to go someplace. So it's a point of, where do you want it to go? That's always my question. People go, I have a will, can I send it to you? Tell me if it's good. All I can tell you is whether it will pass muster submitted to the probate court. I don't know if it's what you want, because you didn't tell me what you want. But you have a document. The question is, what do you want? Where do you want it to go? Who do you want it to go to? What parameters are you setting for it? Those are the things that make up those documents, wills, trust. So it's important of completing a plan. That's why I tell everybody, I don't sell a document, we do planning. What is your plan? I would like everything, like husband and wife would like everything to get to my kids. Okay, so then we need to talk about how that's going to happen. Who's going to be the responsible party? Well, I'm going to name my husband as the executor. Okay, well, who's going to be the backup? Well, I don't need a backup. Well, if you both live to 95, I don't know that he's going to act as the executor if you go first or vice versa. You need a backup. We always have to have backups. You got to think past that. You got to think to the point, especially husband and wife, you got to think past the point of, it's really simple to go, the husband, wife, everything goes to each other. All right, well, what assets do you own in your own name? None. Everything is jointly held. Great. The will won't control anything for the first person. First person that passes away, everything is already owned by the other person, which is joint owners. So the will has no control whatsoever. So that leads to the next thing going, well then, okay, so the first person that's going to pass, the first spouse that's going to pass away, doesn't have to do their will. Correct. Which one's that? But we can ignore that. I don't know who that is. If you know who that is, we can figure it out. But that is true. Now you're understanding the concept. The question is, if you have joint assets, meaning if you have, that's the question is people go, should I put my kid on the deed? How many kids you have? 4. My will says it goes to all 4 kids. Yeah, but you put Johnny on the deed of the house, which means when you die, it's John's house. Well, he'll split it with his brothers. Oh. Listen, I hope so. But from a legal perspective, there's nobody to control that. There's no requirement to do any of that. It doesn't work that way. That's not how the law works. If you leave it, if there's a joint owner and the joint owner survives you, it goes to them. Same thing as if you have a beneficiary designation, payable on death, transfer on death, in trust for. All those banks come up with all new names. But basically what that's saying is when I pass away, it goes to my kids. But it's after you pass away. So the kids that, well, I'm the beneficiary. Your mom has to die first. It's not your bank account, it's mom's bank account. So you need to understand where things go, because that's part of this plan. So if I have a will that says leave everything to 4 kids, and that's what I create for somebody, but they turn around and put 1 kid on all the assets, either as a beneficiary or a trust for or as a joint owner, it's not going on 4 kids. It's going to that 1, the lucky one. Then that's who's going to get it all. Plan didn't work out. I just finished up an estate for a couple. I didn't do the will, so I'm going to put that out there, number 1, because I would never do it this way. But when they wrote the will, they left bank account for Wells Fargo to Sun and to TD Bank to the I want to think 20 years ago, they probably had the same amount of money in both accounts. That would be my thought. Otherwise, why would you do something like that? Well, by the time Mom died, living in the nursing home, they came to me to do Medicaid planning for Mom, trying to save some assets, but then Mom passed away, so we never got to that point. Had to deal with the will. Son's getting everything, daughter was devastated, because she didn't get anything. I don't know what Mom's thoughts were, because I just have this document that says that, and it didn't say anything else. I find it to be malpractice, but I'm not on the ethics board of the Bar Association, so I don't know what it was. I'll try and find the good in it. It was probably even, they went with an attorney that says they do elder law and estates and wills, but it says DUI, criminal defense, real estate, tax, business law, elder law. That's not the same thing. It's not what I do. I only deal with this. So, number one, I would never let a client do that, and if they demanded I wrote it like that, they would sign a waiver. Because I don't want to deal with this later on when it comes out and they say, why would you write it that way? I wouldn't. It doesn't make any sense to me. It's real simple. How would I have written it? Real simple. Assets, pay the bills, pay the taxes, everything's left 50-50, 2 kids. Problems. That's how it should have read. You get into specific assets, you have a big risk that they're not there at the end of the day. Life goes on, you don't know how those things are going to go. So if you want to accomplish something, you got to accomplish it the right way. That's why I would say it's about the planning. It's not about that. We live in a world now where people go, oh, you know what? I can pay $300 and I can download this document offline. I hope it works. I have probably 5 to 10 of those cases in my files right now that I'm working on that you can tell that's not what they were trying to accomplish. They're stuck with something. I have one right now where daughter put her name on, was helping Mom. She's claiming she's going to follow Mom's will. I hope so. She doesn't have to. She got everything by having her name on the documents. On the bank accounts. But her will, Mom's will, didn't leave her everything. It actually left her a third. Mom had a whole bunch of people in there, and this daughter was only getting a third, and then the other 2/3 were split by a bunch of other people. That's what Mom's wishes were. So what's going to happen is we're going to finish the estate. I'm up to the tax return. I've set the tax return in. The state will take 6 months to verify it. Then once we get that, the daughter's claiming she wants to sit down so that I can break it all down, and she can now gift, because it'll go from her to there. The one with the son and daughter, he's claiming he's going to give half to the daughter, or to his sister. He doesn't have to. I can't make him. There's nobody to report it to. That's the rule. So we have to finish the estate. Once the estate's done, there's money in the account. He will make a gift of, I think there's like $90,000 left. He'll make a gift of $45,000 to his sister. At that point, he'll have to report it to the IRS, do a gift tax return. Not that big a deal. Won't be hit with any taxes, but he has to go through those steps because we have to make sure everything is done correctly. That's the biggest part of all this is what is it that you want to accomplish? Because remember, at the end, the power of attorney, for the most part, healthcare power of attorney, the will especially, you're not here to make sure it's followed. And it's going to be followed to the letter of how it's drafted. So if your plan is bad, or you alter the plan, because I've had people alter the plans, they come back later on, and all of a sudden daughter's name's on the bank account, I check my files, and you weren't on that bank account before. Well, I put my name on, but why would you do that? Because you now got ownership of that bank account. That was supposed, you have a power of attorney, you should put your name on there as power of attorney. Well, the bank said this would be easier. Do you want to do it right, or do you want to do it easy? There's 2 different things. Same point, it's you want to do these things right. Because you can't fix it, you can't change it later on. We're kind of stuck with what we have. We're stuck with that kind of plan. So there are options out there. There's a lot of stuff on the internet. There's, and I get people all the time, they read this, I can do this, I can do that. My position to it is you're probably reading it correctly. You're reading that sentence, and you're trying to make that answer fit your fact pattern. It's not how you do math. You have to have your fact pattern and then find the answer. Can't go the other way around. And that's a lot of times what people do in these situations. They're trying to make, 5 fit 2 + 2 as the fact pattern. Doesn't work. 5's correct for a lot of different fact patterns, just not yours. So it's like, well, we can do it this way. Yeah, but here's the problem. 5 things could go wrong. I don't know that you want to do it that way. We do it this way. But Google said, okay, be careful. You know, I don't know what it was basing its answer on. I don't know what the AI metrics were of what it was basing its answer on. And maybe that's correct in Texas. Because every state is different. There's different rules. I practice in PA and New Jersey. I lived in Holland for many years. I lived in Fairles Hills. I have an office in Feasterville. I practice in PA and New Jersey. I have clients all the way out as far as Pittsburgh, and I got clients throughout the whole state of New Jersey. Because I specialize in this stuff. I don't go to court. I don't do any of that kind of stuff. That's not what I do. I go strictly with state planning and elder law issues. Any questions? I know I talk fast. I have some stuff out there which is just basic stuff that we talked about. So if you have any questions, please, happy to answer. So with a will, that's a basic document. Basically says, here's where I want my stuff to go. But remember what stuff it is. It's just the stuff in your name alone. So husband and wife, everything jointly owned, it really applies for the second. Just the way it's going to work. All the time? No. Where it's going to go to. You might not have to probate the first one. What probate is, people hear a lot, anybody hear, do a trust, that way you can avoid probate. Okay. You can avoid probate. The question would be why? You spend thousands of dollars for a trust, you spend hundreds of dollars to open probate. It can't be about money, because that's not, one is not equal to the other one. We get into trust when there's more control issues. I have a disabled child, or I'm a disabled beneficiary, this is what I would want to do. Or I'd like to leave it to my kids, but I don't want them to get everything at one time. I'd like them to get $10,000 every 6 months for the next 10 years. Can't do that with a will. You have to do it with a trust. So sometimes we create trusts in the will, different things, because they don't need it right now. I have a disabled child right now, we can do a special needs trust. There's all kinds of different trusts. It's all based on why, and that's exactly how I handle it. People schedule a consult, whether on phone, on Zoom, or in person. I need to do a trust. My response is always the same. Why? And then they look at me because I'm supposed to tell them why they need a trust. They didn't tell me anything yet. Why? You came here, told me you're telling me you need a trust. Tell me why you need a trust, and we'll go from there. And most of the time is, so-and-so said I need a trust. Then we start talking about why, what they want to do. That leads us to it. Sometimes, yeah. I have a business. I have 4 kids. I want the one kid to have it. I got stock. My accountant has me, sending stock to him on a yearly basis. Perfect. That's a good thing for taxes. And the goal is going to be to get the son all the stock and be the 100% owner before you die. You get around inheritance tax that way. It's a good plan. Yeah, put that into a revocable trust while you're alive. The goal for that is that you can move all that out and the trust is gone before you die. That's a stopgap. God forbid you pass away during life. There's reasons for it. There's always reasons for them. And it can be very simple, it can be very complicated. It really depends on what your situation is. So it's very important to figure out what the situation is going to be. It leads us into elder law. My elder law side of it is, as I said, long-term care. Nursing home, assisted living. I'm pretty sure that no one here is going to assisted living or nursing home. In your mind, you're 100% sure. Because nobody plans for that. I mean, every time I have a consult, it's like, my mom's not going to nursing home. I get it. My mom doesn't want to go to nursing home. Listen, if she wants to go to nursing home, then something's really wrong. She shouldn't want to go to nursing home, okay? They're filled with people who said the same thing. And hopefully not. Hopefully you won't. The question is, what can we do? That's what we deal with. Because again, all of those kind of stuff in here is that, we get into this different kind of planning. It all depends on Medicaid planning, but it's mostly about asset preservation. Whenever somebody gets sick, can we save any assets? Sure. There's ways to save assets. That you won't find on Google. Okay? But from an attorney perspective, if you have a spouse that's going into a nursing home, we pretty much can keep almost all the assets with the healthy spouse. Won't find that out. Nursing home won't tell you that. No one's going to tell you that. You don't read it in the regulation. It's a point of the way the rules work, is that we're able to make that work. Okay? Nothing illegal, it's just the way the documents read out, or the way the agency regulations read out. We can keep almost everything with the healthy spouse. Okay? Some limitations. Got $5 million, not gonna happen. Could, the regulations allow for that. I just wouldn't take it, and the few attorneys like me that just do this, I don't think any of them would take it either, because none of us like to lose. I don't want my client being the test case for Medicaid to argue, to close these loopholes. $1.2 million, $1.3 million, $1.4 million, sure, and any number less than that. That's probably the biggest extreme that we would go. But you could see, if there's no healthy spouse, we got kids, maybe 50 to 60% of the assets is the average that we can save. So there is asset preservation to be done if somebody is going into long-term care. The sooner you get ahead of it, the better it is, and the more we can protect. Yes, sir.
We've been talking about monetary issues. What if the legacy is things, like I have a collection of Indian arrowheads that my father and his brothers collected on the farm in Ohio.
Okay.
And I want it to stay intact, but I don't care which kid it goes to. I just want it to maybe rotating.
Well, those are what we would call intangible or tangible personal property.
Okay.
Okay. Listen, if it's insured and it has a high dollar value, then the state would expect inheritance tax to be placed on it. But without that, we'll call it tangible personal property. You can leave it to whoever you want. I don't know whether you could, you most certainly could put them in the trust and then have the trustee rotate them around to the kids, but there's no way to make the kids take it. And I'm gonna make a joke about it, but using my own family. My mom is pushing 80 years old, and she's got all these curio cabinets throughout the house. Okay, so the room that should be real big is real small, because these cabinets all around the walls. And they're filled with these bells and angel things and all this kind of stuff. For her, they are, priceless. Okay? There's 4 of us. None of us are taking them. So.
Have you told her?
Yes, and she doesn't listen. So I'm like, you're gonna need eBay, something, do something with them, because none of us are taking them. But not the case in there. So you can't make somebody take it. But you most certainly, in your will, or in any whatever distribution document you utilize, can put in there where you want them to go. You don't want them to go to somebody who wants them, realistically. Like my mom needs to find someone that wants them. Her 4 kids don't want them. She needs, suck up to the grandkids. Maybe one of them will want it, but none of us, first off, different generation, and I'm not gonna have curio cabinets all over the house. So I have no place to put them, even if I wanted to keep them, and I'm not dusting them either. So, it's those are the kind of things. So you have tangible personal property. Some people have a car collection. Well, they're titled, so we can't get away with that being tangible. We're gonna have to give them straight out and pay a tax on the value of the cars. Depends on what you have. Guns, people have guns. Okay, I don't know much about guns. The rules are a little murky. My interpretation of it, and what I try to tell my clients, is that get them to whoever you want to get them to while you're alive. That way you make sure the paperwork is done correctly and there's no issue. Otherwise, you leave it to an executor to deal with it, and maybe they're not a gun person. Now, they don't even know, am I supposed to get a permit? Do I have to get a permit? What do I have to show? Get over here, and you don't get many answers from the government. It's not like you can go. Maybe guns, because the sheriff's department handles that, and you get more answers there. But if you're dealing with probate court, you're not going to get answers because they're not allowed to give legal advice. So they normally say, where you live? Okay, look at the list, and here's an attorney right there. Call him. So that's what they would do. But you can most certainly leave all of that. You just have to pick the person who really wants them. But you can't make them have it. No different when people leave it. Well, I'm leaving this house, I'm leaving it to the kids. Wait, you're leaving all 4 of your kids? Good luck with that. They're all going to be partners in the house. You're going to sell it. No, we want to keep it in the family. No, one person, maybe one wants to have it. That means you're going to buy out the other 3. So it's realistically, what is it it's trying to accomplish? You know, and because it's your deal, it's your thought process, and you have to think a little bit outside the box. Going, do they really want it? You know, and you know, like I said, I told my mom, I think she thinks we're kidding, but you know, junk loaders are going to take it away. That's right, Dumpster. Not on me. But you can do all that. It's stuff that you have to think about. So most of the time when I'm dealing with this kind of planning, it's a homework. You know, sometimes there's so many things going on. They go, just tell me what to do. I can't tell you what to do. I can tell you how to do it. You got to tell me what you want. Whatever you want, I can. You know, for the most part, as long as it's not illegal or kind of crazy, we could do it. I had one lady that said, I want to leave this to my son, but he has to do this. I'm like, you can't put a contingency on it. First off, you'll be dead. Okay? Pretty much that's probably the most important part. And the second part is who's going to hold him to it? No one's going to do it. You're not going to do any of those kind of things. So it's like, you want to leave something, leave it. I have a husband and wife, and they have 2 kids, and they have 2 daughters, and each daughter has 2 kids. So husband left everything to wife, anything, you know, she went first, everything goes to the 2 daughters. Wife reads everything to husband, if he goes first, everything to the 4 grandkids, nothing to the daughters. Don't know why, don't care, don't ask. Now again, my staff gets mad at me because I don't ask. You know, they see it when they're printing out the documents, getting everything ready for signing. It's like, well, why did you do that? I don't know. Ask them when they come in. I mean, I never ask. I just know that that's what she wanted. But, I mean, I had a grandfather that easily every 2 weeks, he was in an assisted living 3 minutes from my home. Every 2 weeks, call me, come over, I gotta talk to him. I come over, talk to him, he's changing the will. This grandkid didn't call, he's out. This one came over and he was being really nice, so we're gonna add some more to his. You know, which, you know, I'm the oldest, so there's, I don't know, he had 15 grandkids. I'm the oldest. I'm getting nothing. And I'm not charging them to do the will. So I'm like, listen, once a month we'll talk about the will. I'll see you next weekend, but that's not your once a month. So no will. You know, and that's just what we had to do. Over and over and over. You can do what you want. You know, paying client, I do the same thing. It's like, listen, I'm charging you. I don't mind making a change, but you can't keep doing this. Because at that point, at some point in my mind, I have to go, are they really actually being reasonable? You know, do they really know what's going on? Or something starting here that's making them unable to understand what their actions are? Because that's what's really important. Especially when I get into elder law side, my mom didn't do any of these documents, and oh my God, she got a diagnosis of dementia. Okay, well, how is she? Well, she's okay. You know, she gets a little forgetful in the evening. Okay, she's starting to sundown. It's, you know, brain gets tired. It happens. But if she meets me at 11 o'clock in the morning, will she know? Can she sit there and have a conversation with me? I'm not going to quiz her on, you know, what the Fed's doing with interest rates this month. It has nothing to do with any of that. How many kids do you have? Okay, if something happens to you, who do you want in charge? Who do you want to help you with your make medical decisions? Can she answer all those questions? If she can answer all those questions, I don't care about the diagnosis. I can back up any argument. If there's any challenge, I can defend myself for why I did the document. But people have to be honest, too. At the same point, you know, mom comes in, sits with daughter. Okay, how many kids do you have? You know, I have one daughter. Okay, you know, who is it? I know who it is. It's the one sitting right next to me. She gives the name, but she doesn't look at the daughter. So I'm like, well, who's this? That's my mom. You know, she's 90. No, it's not your mom. We have a problem. She can't identify the woman sitting next to her. I can't really answer to that. You know, and I did a power of attorney. We were trying to change the power of attorney. The wife had dementia, and it was getting worse. She knew me when I walked in. They weren't leaving it to their kids. Their kids fought all the time. They weren't going to deal with that. The husband had a brother, lived in the house next door, lived on a farm right over in Jersey, right over the bridge. And he got diagnosed with cancer. He wasn't going to be here that long. He was very sick. So they wanted to change it real fast. Well, my problem is I couldn't change hers because she wouldn't give me a name. Like, and I said it, and I went out to my car to get something at the same point, so I let the husband talk to her. When I come back in, she's gonna tell me she wants Mary Beth to do it. So I came back in, and I was like, okay, so who do we pick? John. And I said, I can't do it. I can't do it. In fact, the daughters got mad, they called, I'm like, it doesn't work that way, I can't do that. They ended up going for guardianship down the road for mom, the guardianship attorney, small world, knows me, called me up, said, Scott, without violating, any attorney-client, can you tell me what happened? I said, yeah, I'll tell you, even if it violates attorney-client, because you need to understand this going for the guardianship. I said, when I went out to do this and make the changes because the brother-in-law was sick, she would not name the person they wanted to name. I know who she wanted to name. I knew exactly what was going on, but she would not name the person for me, no matter how hard we tried. I said, honestly, I left the room, I let them, write it on a piece of paper. I did everything I could do without writing it down. I'll make it work the best I can because I know what they're trying to accomplish. But there is ethics that I have to abide by. If the client can't tell me who it is, I can't do it. That's the problem. The same thing with mom, they can't identify daughter. She identified daughter, but she had no idea that's who was sitting next to her. So those things make it, limits my ability to do things. But because this is all I deal with, sure, if I can make it work, I make it work. At that point, is there an option? I don't know. I'll say it. Is that those are people that get, just a blank document offline and have a notary come in and, because the notary's not asking any questions. They're just making them sign. Maybe that gets you around it. I don't know if ethically I could ever tell somebody to do that. I'm hoping that if that's the situation, they think outside the box. But you have to be careful because I don't know the family dynamic. Because that's usually where the problem is. Everybody gets along until something goes wrong. Then we have issues. That's normally how the things work. No different with, it all goes to one son, he'll give it to his siblings. When you're not the centerpiece anymore, everybody has their own world, has their own lives. And then realistically, the way things work is that sometimes people go, I don't need a will. I got 2 kids, I die, or my wife dies first, I die, everything goes to my kids. Yes, in theory. But there's a progress that has to take place. I have a case right now in New Jersey where, he died, no will, son and daughter. Son has a drug and alcohol problem. He's nowhere to be found. Daughter doesn't live in the States, so she can't be bonded. If there's no will, you have to be named as administrator. If the court is going to name somebody, they require you to get bonded, which is insured. So if anybody has a will, you look at your will, it says something about, my executor doesn't have to be bonded. They all say that. The reason is what they're saying is, I picked this person, I trust it, they don't have to be insured to do the right thing. I trust them. Fine, but if the court names them, they gotta be bonded. My client lives out of the country, can't be bonded. Okay, called around, 60 people, or 60 different insurance companies. Nobody would bond him. No assets in this country. It's still gonna get to those 2 kids because he died without a will. But who's in charge? Daughter talked me into it, said I would do it. Fine, filed the paperwork, notified the son. As of 11 a.m. on Monday, whatever, the 11th, we're going to name, attorney to do this. The court went, gave the information to the son. The son showed up at the courthouse that morning, said, I disagree with him being named, and then disappeared. So now I have to file a case with the court saying, order to show cause. What's his objection and what's his alternative? Which will be nothing, because he has an attorney. Small world. I've already heard from the attorney that's been dealing with him. He took Dad's truck after Dad died, crashed it, ended up, with a court case. Those attorneys call me, and I said, "Are you dealing with the estate?" It's not a chance. We don't touch this client. Again, just wanted to know what you were going to do with it. So now we have to go that way. So that's would have been easy if it was a will. Daughter would already be named. We'd be done this case. Instead, she's in another country paying mortgage, keep the house. But
I was wondering if you could discuss a little bit about revocable versus irrevocable trusts and
Sure.
When they're appropriate or not appropriate.
revocable trusts are basically yours. The business that I talked about earlier, moving stuff around, it's It's your trust, you put everything in the name of the trust, so you sign trustee after your name. It'll avoid probate, okay? It won't avoid inheritance tax. You still get stuck with inheritance tax, depending on who you're leaving the stuff to. But that's a revocable trust, meaning you have control, you're the trustee, you have somebody named, if you become incapacitated or die, it becomes irrevocable at that point. The reason we would deal with irrevocable trust is if mom gets that diagnosis, they have a house down the shore, whatever they want to keep, and expects that they're going to end up in long-term care at some point down the road. Who pays for long-term care? You do. Or you can apply for Medicaid if you have no money. That's it. There's only two choices. Medicaid has a 5-year look back. So what people do is we put assets into this irrevocable trust. I don't want you to give it to the kids now, because then it's theirs. Who knows? We stick it in this trust so at least we can put it to the side. If we can get past 5 years, those assets won't count. When we add up what assets you have, those don't count. The house, the second house, nothing, okay? Is there tax consequences? Yeah, sometimes, but they're definitely not offset by the $15,000 a month in the nursing home bill. So you would do an irrevocable trust. Somebody else would be in control, you give up your assets, we put them to the side, you live your life without them. No way to change that. Trustee can break it, trustee can do some changes, but we use them mostly in asset preservation for Medicaid purposes. Revocable trust, you control that asset. You control the money that you put in there. A lot of times people do that to avoid probate because that's what they heard on the TV. I really get it when people are dealing with businesses and stuff like that. That's when they really come into place. I used to do them all the time in New Jersey because New Jersey had an estate tax at $650,000. So you put your house, savings, IRA, all of a sudden your estate is over $650,000. Put the house into the revocable trust, solves the problem. Because when you die, it becomes irrevocable, it's not part of your taxable estate.
When you put something in the house in irrevocable trust, and the trustee says, oh, I don't want you living there anymore, can I kick you out?
Yeah, in theory.
Yeah.
But, the trust itself, the one I would write, I give you the right to live in it.
Okay.
It's more of the issue going, maybe the trustee gets to a point when this house is too much for you. And you're going, no, it's not. The bed's in the living room. You haven't been upstairs where the shower is in months. It's too much. Let's sell this, move it into a ranch house. So the trustee's trying to help, but the person who did it is now getting to the point where they're not being reasonable. So that's sometimes where you get the clash that comes up. But yeah, I guess if you have a terrible trustee could get rid of things, but realistically in the trust, we document that you can live in the house.
Well, when my mother was by herself, she sold her house to my brother and I for $1.
Okay,
But we gave her right to life will.
you gave her,
She could stay there.
did you do a life estate in a life estate deed?
Yeah, where we could not throw her out.
Right. You had a life estate.
Yes.
Yeah.
Because it saved a lot of money.
Yeah, but what you ended up with, did either one of you, your brother move into the house?
No, we sold it.
Then you got hit with capital gains.
Well, no, but it's still.
You got hit with capital gains for that. If you would have done the trust, put the house in trust, she put the house in trust to go to you guys afterwards. Right, there would be no capital gains. The reason being, you buy a house for 50 grand, you live in it for 40 years, it's now worth 400, it increased the value 350 grand. Well, government is not gonna go, congratulations, keep the money. It doesn't work that way. They wanna get the money, but there's some regulations in there that says, listen, if it's your primary residence, you get to keep it. But when you put the kid on it for $1, the kid bought it for nominal. Again, you put it for $1 because it's basically a contract. There's gotta be what they call consideration. There's gotta be something, so that's why we use $1. It doesn't mean anything. But what ends up happening is that means the kids, in your case, and too bad, you put it out there, so no attorney-client violation from my perspective, is that what hadn't happened in your situation is you guys became the owners of that property at 50 grand. So it's like they bought it 40 years ago, even if they weren't alive at that time, because they took her what they call basis. Then what happened is because neither one of them was primary resident, it was an investment property for them. There's no protection from that capital gains increase. So at that point, you got hit with a capital gains tax. Whereas otherwise, what you would really want to do is people say, should I put my kid on the deed? No, what has happened, if the kid's not gonna become a primary resident of the house, let him inherit. 50, it's now worth 400, pay the inheritance tax on 400, this is 4.5%. Yeah, nobody likes paying tax, but it's better than the capital gains tax. And then sell the house for 400, there's no capital gains. So the state paid the 4.5% inheritance tax, kid gets the rest of the money. That's the best way to do it. But yes, doing a life estate, problem with the life estate, where life estate blows up, and I have some people who've done that. They have a life estate, mom's now in a nursing home, they've been wanting to sell the house for years. Problem is, they can't sell the house because I got mom on Medicaid, she's in a nursing home.
Right.
If they end up selling the house, that life estate has a dollar value. So now mom's gonna lose her Medicaid benefit until they get rid of the money.
Well, my mother did us a favor, she died, remember.
There you go. That worked. And that's the whole point. And that's exactly what ends up happening. That, you know, you got multiple things that you can control. So you don't need to do any planning. You know, people say, well, you know, do I really need to do a will? You know, if you're not gonna die, don't worry about it. Waste your time. You know, I think it's a waste of time. But ultimately, out of all of these things, that's the only thing that I can guarantee is gonna happen. I know that the saying is, you know, the only thing you can guarantee is death and taxes. Nope, death. Okay? You know, I got a client in a nursing home, owes the IRS money, owes the state money. Nobody's getting paid. We're gonna pay the facility because that's what we have to pay. I'm gonna get paid. And then Medicaid's gonna start making the payments. And then when she dies, the IRS and then Medicaid and everybody else can stand in line. She didn't pay any of those taxes. The way it goes. You can't pay something if you don't have it. You know, and now again, I'm not advocating for not paying what you're supposed to pay, but you know, somebody gets sick, long-term issues come up, we don't have the money to do it. We just don't have the money to do it. We have to worry about where the money's gonna go.
See, the other thing too is, Bryce, taking all these assets away from my mother. She was able to get PACE.
Yeah, you basically got her in the Medicaid program
Yeah,
because she didn't know anything. But you had to go through 5 years before you did that.
Right.
So yes, that's the same thing. So we would use an irrevocable trust because, to put it this way, in that kind of part, I mean, mom was protected with a life estate deed. But I've seen it where they, you know, basically sell it to the kid. And then that gets back to the same thing. Can the kid sell the house? Sure. Could the kid lose the house? Because the kid died? You know, that's also adding your kid to, say you put your kid on the bank account, now he's joint owner. Well, in Pennsylvania, if you leave stuff to your kid, it's 4.5% inheritance tax. So that way, if your kid's on the bank account as a joint owner, what ends up happening is that, you know, that $100,000 that you have in the bank account, it goes to the kid, and what ends up happening for inheritance tax, as long as within, you know, you lived at least a year since you made that transfer, what ends up happening with inheritance tax is it's 4.5% for $50,000. Because half of it was yours, that's what's taxed. The other $50,000 belongs to the kid. That's a great way of trying to get around inheritance tax. Do this long enough, I got the way, you know, I got a story for that one. Kid dies first. Now mom just paid 4.5% inheritance tax on her $50,000 because she put kid's name on it. Hey, you want to try and sneak something past the government? You got an issue. You know, I'm okay with it. I think it's fine. There's a risk. That's the risk. Then you get the big story going, oh my God, it was my money. Why? How can they do that? Listen, one thing I can't stand doing is, you know, defending the government. Okay, but they're right at this point. You can't go around them and, you know, try and circumvent it without taking that risk. You're taking a risk. So I don't know if the risk is worth it. I get clients to do it. Now, again, like I said, not my choice. As long as they're not doing something illegal. And we're all adults. We're allowed to do things that are risky. We're allowed to do things that are stupid. What we're not able to do, especially as we get older, is put ourselves in harm's way or someone else. That's what I have to end up doing. Like this, I can't do that, can't do that. So those are the kind of things that come up. And it, you know, can be crazy. I've seen, you know, enough to write, you know, 27 books. And for the most part, most of them, as crazy as they sound, were the best intentions. You know, my grandfather with his craziness, it's just where he was at that point. That's where he felt. He didn't call me when they said they were going to call me. I'm not leaving anything. It makes sense. Drove me nuts, but it made sense. You know, the one that did the will, leave this to the daughter, leave that to the son. It doesn't make sense from my perspective from an attorney, but it's not uncommon for me to have somebody say that to me. Because I do this all the time. So for me, it's easy. I talk fast. I understand all this. Sometimes it goes over the head. But that's why I tell everyone, just let me know, call me, I can answer the questions. But I'm thinking of what the possible issue is later. Yes?
We just have a couple more minutes.
Okay.
I don't know if there's any wrap-up or final questions.
Yeah, anybody have any questions? Yes, sir.
From past experience, my father had a property and he gave it to all the kids. So the downside was we wanted to try to keep it in the family,
Mhm.
but one of the siblings says, I want my money.
Yes,
So,
has to buy them out.
we had to buy her out.
Yeah, that happens. I mean, I had a client that has a house down the shore, wanted to leave it to the 4 kids, only one of the 4 kids ever got to the shore. And so as we talk about it, I'm like, this is gonna be a real problem. You know, you're gonna have to come up with the money to buy that shore house. So now what are you gonna do? You know, and it's a tough decision to make. You know, at that point, if the kids aren't going to want it, you're only gonna have one taking advantage of it. I know as parents, like I said, I got 2 kids. I would wanna hope that they're on the same point. I've done this long enough that I'm not gonna demand that they become partners. Just can't. You know, and you gotta think about those kind of things that when you're doing the planning, because it's your plan. So if there's any of that kind of stuff that comes up, give me a call. Like I said, I got some stuff over here. Please grab stuff. Happy to talk. I do consults over the phone. I do consults in person. I do consults in Zoom. I do consults in, you know, I meet people wherever they are, whatever we have to do. Because this is a conversation that I came out and did. If you guys have issues, questions, consult, there is no consult fee. Okay, because all you're gonna do, when whoever answers the phone, they're gonna answer the question, say, where'd you get our information? At the church, when Scott was talking, that waives the consult fee. So that's how we do things. And even when I do a consult fee, my consult fee is added into whatever we do. So it's just a point of I'm gonna come out and talk, then, you know, if you're gonna do documents, then we'll just, whatever you pay for the consult fee, will be basically a down payment for what we're doing. That's what I try and do. Now, understand, elder law and estate planning is those kind of things, what I talk about. If you're old and you're having trouble with your rent and the landlord, that's not elder law, okay? That's landlord-tenant. But that's, sometimes I get that. Calls like that from landlord-tenant, and it's like, you know, well, you're the elder attorney. Okay, I've got a lot of gray hair, but what is your legal issue? That's landlord-tenant. Everything falls into a thing. That's why I said, this kind of planning, I would always tell everybody, there's not a lot of us that do this. So mostly a boutique stuff, that's all we do. So if you see somebody says, I do estate planning, but it's one of 12 things on their letterhead, and they probably could do a good job. I just don't know how much they know. It's hit or miss for them. For me, it's the only thing I deal with. Long-term care issues, all that kind of stuff. And we would talk about it. What I can tell you, besides you planning who to be your power of attorney, wills, where you want your stuff to go, some of the other stuff is an if I get sick, what could happen? And those are the kind of things you have to think about. Do I want to take assets out of my name and, you know, put it in the name of the kids, just in case I get sick? Fine. In that case, you said mom passed away at home. Now she got some government benefits, which, so you don't know what's going to happen. So we play it out. I've had people that we did this Medicaid planning, went into a long-term care facility, died 2 weeks later. You know, sure, we could have not done it, but it'd be a different conversation if you lived for 5 years. So those are the kind of things that happen. But I appreciate you guys coming out.
Thank you.
Thank you.
Thank you.